information. Welcome everyone to today's Title Topics webinar. These are ALTA's free presentations that we offer every month on issues important to title professionals. I'm Jeremy Yowie, ALTA's Vice President of Communications, and today we've got a great program lined up that's going to dig into the Department of Labor's new overtime rules that go into effect December 1st of this year and really could impact every title and settlement company across the country. Before starting, I just need to touch on a few housekeeping items. A copy of today's presentation can be downloaded from the handout section of the GoToWebinar window on your computer screen. If you're only listening to the audio, please send me an email at jyowie@alta.org. That's jyohe@alta.org, and I can send you the material after the webinar. All participant lines are muted for today's presentation. You can submit questions through the question box, and we'll hold some time at the end of the webinar. As an added benefit, today's presentation is being recorded. After it's processed, the recording will be available on ALTA's website at alta.org/title topics, and that's alta.org/title topics. Need to thank Fidelity for sponsoring our Title Topics webinars this year. Their support allows us to continue providing these educational opportunities free of charge. And with that out of the way, let me introduce today's speakers. Joining us today is Shannon Farmer of the law firm Ballard Spahr. Shannon represents public and private employers in a broad range of labor and employment matters, including wage and hour claims under the Fair Labor Standards Act. We also have Brent Scheer. Brent is Chief Financial Officer for Agents National Title Insurance Company, a certified public accountant. Brent is chair of ALTA's accounting committee and serves on several other committees and task forces. Agents National is celebrating its 10th year in business, so congrats, Brent, to that milestone.
Thank you.
Before turning the presentation over to our speakers, we just wanted to have a little bit of attendee interaction and ask a few poll questions just to get a little bit to see how our folks are handling HR and payroll. So let me launch the first question here, and if you could answer whether or not you outsource HR to an outside firm or attorney. I'll give you just maybe 30 seconds so we can collect some data and then move on.
So Jeremy, I see that you did not include the poll question I suggested, which is how many participants are still in their pajamas this morning?
Oh, the next slide will ask people if they think Brent Scheer has pants on or not.
Right.
All right, we've got about 70% voted, and we'll go ahead and close it, and we'll share the results, and 82% do not outsource. So let's hide that one.
Information.
Yep. Now let's ask the next question. If you outsource your payroll function, and if you all would mind voting on that one as well. All right, a few more seconds. We go. You guys are all paying attention. Almost 80% have voted on this one already. All right, go ahead and close this one, and we'll share the results. And outsource payroll, 51%. So
I think QuickBooks payroll has been a godsend in terms of being able to do payroll internally. So.
Okay. All right. Well, good information to know. How folks on the line are handling these two things. And with that, Shannon, I will turn the presentation over to you.
Thank you so much, Jeremy. So what we're going to do today is we're going to talk about a little bit about the basics of the Fair Labor Standards Act. That is the federal law that sets minimum wage and governs overtime payment for workers. And we are not really going to talk about state law issues, although you should always want to keep those in mind depending on some states. Excuse me. We're going to talk about the ways that employees can be exempt from these requirements and what you need to be doing to get ready for the regulation changes that are taking place December 1st. So let's just basically start with a little bit on the background of the Fair Labor Standards Act. So it's got the minimum wage requirement, and then what most people are worried about here is going to be the overtime requirement, and that is that an employee who works more than 40 hours a week, and it's a work week basis, not 80 hours in a pay period, is entitled to overtime compensation at a rate of 1.5 times the regular rate of pay. And although outside the scope of this webinar, there's other things besides just base salary that may have to be included in that regular rate. There are certain classes of employees who are exempt from these minimum wage and overtime provisions. We're going to talk about that. And then you always want to remember that there can be state laws that have higher minimum wage, that have different rules about who's exempt. So you always want to know what the law is in your state as well, because even if you're okay under federal law, you could still be sued or subject to an enforcement action under state law if your state provides additional rules. You can also have private agreements like a collective bargaining agreement that may require you to pay additional overtime, or an individual employment agreement. And one thing that's very important to keep in mind here is that these rights are non-waivable. That means that you can't go to an employee and say, you know, we can't really afford to pay you in accordance with the Fair Labor Standards Act, so instead of paying you overtime when we're required, we'll give you some additional vacation, or we'll pay you additional health insurance benefits or something like that. You can't make a deal on this. You cannot pay people in ways that don't comply with the Fair Labor Standards Act, because even if the employee agreed, the Department of Labor can still come in and do an audit, and then you're still going to owe them the money. So it's non-waivable. Okay, so let's move on now. In talks, just the very basic question is, are you covered by the Fair Labor Standards Act? So it is different than whether some employees may be exempt from the overtime provisions. This is the question of, is your business covered at all? And here's the rule. It's called enterprise coverage. You have to have at least 2 employees and an annual volume of sales or gross business activity of $500,000, or be a hospital, nursing home, school, or government agency. And that's gross business. So if you have revenues of $500,000 and at least 2 employees, you're going to be covered as a business. So most private companies, except for very small businesses, are typically going to be covered under the enterprise coverage. But even if you're not, and if we can go to the next one, Jeremy, even if you are not covered as an enterprise, so if you're small enough, you may have individual employees who are still covered. And that would be anybody who regularly engages in interstate commerce. And that's really very broad. So, for example, if you produce goods that are being sent out of state, but that can be something as simple as a secretary who types letters that are being mailed out of state. That's considered to be interstate activity. Making phone calls to people in other states. It's processing, for example, credit card transactions involving people in other states. That's all interstate commerce, and there is not a dollar threshold. It's just regular. So in financial services industry, probably most employees who would be involved in any of those things, and if you're talking to, lenders in another state, that's going to be interstate commerce for this purpose. Most people are going to be covered. So we're going to operate under the assumption that everybody that we're talking to is covered by the Fair Labor Standards Act in terms of it applies. Now we get into this issue of, are your employees exempt from the minimum wage and overtime provisions? So that's when we're going to talk about exempt or non-exempt. Non-exempt equals you have to pay overtime. Exempt equals you don't. So we have these major categories of exemptions. They're sometimes called the white-collar exemptions. And then there are some partial exemptions in certain industries, law enforcement, nurses, things like that. We're not going to talk about those. We're going to talk about these major categories of exemptions, because that's where, if your employees are exempt, they're going to come into place. So if we can go to the next slide, before we go into the details of the exemptions, one of the things that you need to keep in mind is record keeping. The Fair Labor Standards Act requires that you keep records of the work hours of employees. There's no format that you have to use. So you can do paper timesheets. You can have employees keep their own time and submit it. There are companies that there's apps that you can use for cell phones. There's dial-in programs for phones, especially like a lot of call centers use that. There's login things related to computers. I mean, there is no format, but you do have to have that hours. When you have exempt employees, those who are not eligible for overtime, you don't have to keep a record of their hours, but keep in mind that if it turns out that you were wrong calling that person exempt and they're really non-exempt, you're going to have to figure out how much back pay you owe them, and not having a record of their hours worked can make that hard, because anytime there's a lack of records, the Department of Labor and the courts basically ask the employee, well, how many hours did you work? And if you can't prove something different, they basically are going to accept what the employee has to say. And in fact, the Federal Department of Labor, very helpfully, and I'm being sarcastic there, created an app on their website. There's an app for employees where they can put it on their cell phones to track their time. And the Department of Labor has said when they did it, they said, well, this way, this will be proof of what employees are working. But of course, it's not proof, because I could be at the mall and put on my cell phone that I'm working. But that was the Department of Labor's idea, that way it'll be easy for employees to track their own time. But there's no controls on that. There's nothing that prevents abuse just because an employee says that they're working. Okay.
Yeah, and I think, Shannon, on this point, that's where having that document, which God love it, you can use a spreadsheet, which always makes me happy being the numbers nerd, but having a control in place, meaning someone approves that time. So if that person is at the mall, you can have a BS moment and say, hey, you're at the mall that day, take a half hour off. We know you weren't working that time, so done.
Absolutely, yeah. Having a method in place to approve employees' time is very nice, and having people have to submit it in a regular basis is always better, so somebody can't go back after the fact and say, well, here's these 80 hours that, I told them about. So having a process in place where people are regularly documenting and submitting their time, and that's what they're being paid on, and it's being reviewed so that somebody's looking at it and saying, what do you mean you said you worked 16 hours that day? Like, there was a snowstorm, but 2 years later, are you going to remember that? Probably not. So all of that is definitely a best practice. So before we get into the details of the regulations and the exemptions, just want to talk a little bit about, process-wise, what you can do to deal with all of this and figure out where your areas of potential liability are. And that is, the first step of this is a self-audit. And a self-audit is the best way that you can assess whether you're in compliance with the wage and hour laws and regulations. That's going to give you the opportunity to ensure that you're being compliant and try to remedy potential issues before the lawsuit, before the Department of Labor audit. And it can also, if there is litigation, it can also help you to defend allegations, to say, no, we found this problem and we're, looking to clear it up ourselves. So I want to talk a little bit about how you do that self-audit. We go to the next page. The wage and hour audits really have three parts. The first thing that we want to do is look at people's job duties and salary. And are they exempt, meaning we don't have to pay them overtime, or are they non-exempt, meaning we do have to pay overtime? So that's the first piece. Like, do we have people in those right buckets? If we believe, based on their job duties and their salary, and we're going to go over those rules in a second, that these people are exempt, that means they don't have to be paid overtime. There's another piece of that to make sure that for an exempt employee, it's not just how much they earn, but it's also the manner in which they're paid. There's something called the salary basis test. We're going to mention that. So making sure that they're being paid properly. And then the other piece of it is, for those people who are owed overtime, making sure that we are counting all the time that they work. So that's going to be a challenge, especially in today's 24/7 connected world, and that their pay is being correctly computed. That's just that payroll function of making sure that the math is being done correctly. The more complicated your payroll system is, the more you've got, premiums and bonuses and incentive compensation, the more important it is to make sure that all that is being done correctly, because there are rules about how that has to be counted into overtime, and making sure that that is all done properly.
So in this area, guys, this is something that I was talking to Shannon about, which has been wonderful. I'm getting like a front row seat to the all-star here. She's a wealth of knowledge. But in terms of the self-audits, the thing that comes up, from somebody like me who's dealing with this, and how do you figure this stuff out, is first being aware it's out there. But then second is, where's your resources to help you with these self-audits. And we talked a little bit about this before the webinar, and that is, we put those stats up there, and about 50-50 in terms of who's outsourcing payroll and who's not, who's doing it internally. But then as far as HR goes, most of you do that in-house, 80%, something along those lines. And this is where I think we would have to challenge that data and say, maybe it's time to look outside of yourself and get help on this stuff. So your payroll company may be able to help you. I know, like from my background, CPA firms sometimes get involved in this area. But really, guys, a law firm or someone who specializes directly in HR is where you want to go. And the thing that I would bring up here as a consequence of that decision and how important it is, I'm a recovering tax preparer. The big thing to remember is that you, the company, the employer, will be responsible for the decision in terms of fines, penalties, back pay, etc. So using someone, a resource that has the expertise, that can do it, and as Shannon pointed out, making sure your indemnity clause, if something gets messed up, that they will hopefully reimburse you, or you're allowed to get reimbursed for that, is present, is critical, because you're looking to seek the HR horsepower to help you make the right decision, and you're gonna rely on that. But remember, if something's not right, you're the one, the employer, has to pay the fine and the penalty, etc. So that was my one little point here on this one.
Yeah, absolutely. And one other thing to keep in mind when you're trying to decide who's going to do the self-audit is, if you are not doing it at the direction of counsel, then there's not going to be any attorney-client privilege. And you may think, okay, why does that matter? It matters because you may uncover things in your self-audit, and you may need some time to figure out how to deal with them, what they mean. If you're not doing it at the direction of counsel, all of that sort of work product, or maybe if you get advice from your HR professional, or you get advice from that CPA, like saying, oh, you've been paying this person wrong for 2 years, or for 5 years, or for 20 years, none of that is going to be protected from discovery and litigation. If you're having that conversation with your attorney, that is going to be protected in terms of at least when you knew certain things, perhaps. I mean, there's still going to be issues about whether you take action going forward, but think about that. And, all of those conversations with your accountants, with your HR professionals, even if you bring somebody in from outside, if they're not an attorney, there's no privilege there in litigation from the Department of Labor, or if you're sued. Okay, now let's move on to get to the nitty-gritty of how do we figure out if employees are exempt. So we're going to talk about the new rule and this new salary threshold, but also then the duties test. So the thing is, with almost all of these exemptions, there are two parts to it. One is the person paid at least a minimum amount of money on what's called a salary basis? We'll talk about what that means. And then also, do they have duties that fall under one of these categories? Now in May of 2016, the Department of Labor issued this final rule increasing that salary threshold for the exemption from overtime pay. It had been $435 a week, which is about $23,000 a year. Effective December 1st of this year, it goes to this $913 a week, which is $47,476 a year. And also, the Department of Labor put in an automatic escalator so that every 3 years, based on some statistics from the Bureau of Labor Statistics, that for $913 a week is going to go up, and we'll know basically, in advance of that a few months, but it's going to go up, and we have no reason to think it's not just going to go up. But they put it in, and it's tied to the average weekly wage. All right, so let's now talk about this salary basis that I talked about. So for most of the exemptions, and I'll tell you where that's not true, you have to be paid at least this $913 a week, and it's not subject to reduction based on the quality or quantity of work performed. What does that mean? What that means is that if I'm an exempt employee and I come into work on Monday and Tuesday, and then, or, you know, I only work like 3 hours a day, you dock me for that time. If I'm supposed to work 8 hours and I only work 3. So it really is supposed to be, you basically get your salary for the weeks in which you work. There are some situations where you can make deductions. For example, if somebody is out of paid time off and they say, well, I want to take tomorrow off because it's my child's graduation or something like that, you can dock them from that time, but it has to be in a full day and they can't do any work, and there are some rules like that. But the general rule here is you pay that salary on a weekly basis. It's not tied to their hours of work. You can pay additional time. So if you have an exempt employee, they've got a salary, and then you pay overtime, you pay bonuses, you pay commissions. It's a floor, it's not a ceiling. The biggest place where people get into trouble is partial day deductions, where they say, you know, somebody says I'm leaving 2 hours early and they don't have PTO to cover it and you deduct part of a day, which can get you into trouble. Or what do you do about disciplinary suspensions for exempt employees? Can you give them like a 3-day suspension? Those are areas where people get themselves in a lot of trouble with the salary basis. So anytime you have an exempt employee, you want to make sure that you're stopping and checking if you're doing it right before you make any deductions from their pay. Not deductions from whatever PTO bank or however you do your PTO, whether it's vacation or sick or whatever it is, but pay. That's going to be the issue. Okay, so I said to you that I'll tell you that there are some places where these salary requirements do not apply. One of them is outside sales. We'll talk about what that means. Doctors and lawyers and teachers, there is a specific exemption that the salary rules don't apply. And that means not only do they have the degree, but they're actually acting in that. So if you have somebody with a law degree who's not acting as a lawyer, that doesn't count. And also business owners with at least a 20% equity stake this does not apply to. There's also a specific rule related to computer employees, and we'll talk about what those mean, where they can be paid this $27.63 an hour. So let's move on. When we talk about the duties, it's going to talk about the primary duty. That means basically the main thing that they do. So you want to look at the relative importance, the amount of time they spend, and also you're looking at their salary relative to non-exempt employees. Now let's get into the details of the exemptions. We're going to start with the executive exemption. If we go to the next slide. Okay, so we've got the salary requirement, that $9.13 a week, primary duty management of the enterprise or recognized subdivision, regularly directs the work of 2 or more employees. Those have to be employees, not contractors, and they should be full-time employees. And they have these kind of authority about things like hiring and firing, promotion, change of status, or at least like their opinions are given particular weight even if they don't have exclusive authority. Let's go on to the next slide. The important thing to remember is that not all supervisory or managerial employees are exempt. That's a big difference. Like some people think, oh, this person's a supervisor, we can make them exempt. That's not enough, and you can see you really need to go through all of the steps of that, of how much authority they have. A lot of the litigation here has been working level lower level supervisors, first level supervisors, working foremen, things like assistant managers in retail has been a huge area. So there's people with some responsibility, but maybe not enough. Let's go on to the next exemption. That's the administrative exemption. Again, we have that $9.13 a week. Primary duty, non-manual work, directly related to the management of the business or business operations, and discretion and independent judgment with respect to matters of significance. So what does that mean? Because lots of people are going to say, oh yeah, everyone does that. Remember that the Department of Labor's view is that the majority of employees should be considered to be non-exempt. and not every person who is clerical. This doesn't mean clerical. If it's my primarily clerical work, that's going to be non-exempt work. So let's talk about what they consider to be factors on matters of significance, if we can go to the next one. Are we talking about business or strategic planning? Are there decisions that impact business operations or revenue? Does the employee plan or manage a budget? Are you directing the work of other employees or manage major projects? Let's go on to this discretion and independent judgment. What decisions can be made without review? How often is the person overruled? How often are the recommendations followed? Can the person really choose among possible actions, or are you locked in by the factual situation? And that becomes really important. So if you go to the next slide, you'll see why. Because where there's been a lot of litigation is things like executive assistants, insurance adjusters, mortgage loan officers, copy editors, loss prevention managers, and employees. And the reason that is these are jobs where maybe 15 years ago the perception is people had a lot more independent judgment than they do now. Take mortgage loan officers for an example. If previously people could look at a file and say, yeah, I think that maybe there were some guidelines, but people really had some discretion to say, I think we should take a chance on this person, and now that's been replaced by a computer program that spits out the answer. That person probably doesn't have discretion and independent judgment, and that's basically where the Department of Labor has gone over just the past 10 years to saying a lot of positions in the financial services industry where 10 or 15 years ago they would have said absolutely we're exempt under this administrative exemption are now saying it's all so heavily regulated and so heavily controlled that people don't have discretion because they can't make independent decisions. This then ties into this next. Go ahead, Brent.
So Shannon, and again, I'm just a wildly attentive spectator here at this point, but how often are employees' decisions overruled? What I hear that as is, again, go back to self-audit, make sure you have robust job descriptions, they are accurate, they're updated annually, that kind of stuff. But then second, isn't there a burden there to document these kinds of things for or against? And that creates kind of an administrative burden, if you will, in terms of being able to, for or against whatever is happening. It seems to me like there is quite a burden in terms of how to, measure these things and make sure that you, in the self-audit process are giving yourself good feedback and possibly changing an exemption to a non-exempt.
Yeah, I mean, it's definitely something to think about. There's no specific requirement that you keep track of things like this, but the fact is that if there are positions where you know that there may be litigation, you always want to be thinking about it with an eye towards, if we have to defend this in court, what kind of evidence are we going to have? Is there going to be a trail that we can create that shows that somebody sent something through for approval and it was agreed to, or a trail that's going to show, no, it was rejected? Or is there going to be some sort of trail on that when we have to go through and explain how this person has discretion and independent judgment and how they're given the authority to make decisions? So that can be, that can be emails, that can be lots of different things, that can be policies that lay out, what the authority is. But this litigation is very expensive and very fact intensive.
Yes, and those job duties you brought up, which are so relevant in terms of the mortgage loan officer, like you said, it used to be, a lot of discretion there. Now it's check the box in a lot of things, yep. And that works against you in terms of the administrative exemption in category. So, here's the deal. 1,000 of our friends are on. Yikes! Hello. It's scary stuff, guys. I think tell your friends, tell your neighbors. You got to get out in front of this stuff now so you can plan in place. Again, you just want to be fair and you want to do everything right. And last thing you want is to be on some kind of DOL audit. So God help us all.
That would be right. You do not want to be on a DOL audit.
Sorry, I just want to interject real quick. We've had a couple of questions come in, and it's probably gray. Questions regarding if escrow officers and settlement agents, are considered exempt employees. And I think it basically just kind of involves applying some of these bullet points that you just ran through, Shannon, correct? Or no?
Absolutely. Both of those positions, if they are exempt, are going to be under the administrative exemption. And so you're going to have to look at that test. They very unlikely to be under the executive exemption because they're probably not supervising people. And we're going to talk about the professional in a minute, and very unlikely to fall under the professional either. So we're really talking about the administrative exemption, and so it's going to go to how much independent authority and discretion do these employees have. And one other thing that's a hard thing to deal with on the administrative exemption that works against both of those categories of employees being considered exempt is one of the things that the Department of Labor looks at. It makes this distinction between what it calls administrative employees and production employees. Now you might think production and you're thinking, okay, that's like a manufacturing line where you're producing widgets, but that's not what they mean. What they're saying is, are you servicing the business, the CFO, the HR department, who are really providing these kinds of services to the business? When you go back to that original question, are they providing this work directly related to the management or general business operations of the employer or the employer's customer? So maybe a management consultant. Or are what you're doing producing the product of the organization? So if the product of the organization is loans, the people who are producing the loans, in the view of the Department of Labor, are production employees who can't fall under this administrative exemption. So that is another challenge, and that's part of their view on the mortgage loan officers, and really a lot of things in this financial services and the lending industry is they're saying, well, these are really all production employees, and there's not really a lot of discretion, as opposed to, for example, our HR, which is servicing our business. So it is a very challenging set of views when it comes to the financial industry. The Department of Labor has been pretty aggressive in saying, for the most part, their view is that most people are going to be non-exempt, meaning they need to be paid overtime. Let's move on now to the professional exemption. Again, we have the salary basis. So here we've got knowledge of an advanced type in a field of science or learning, and what we're really talking about here is that's going to require specialized intellectual instruction, or maybe you can do some combination of intellectual instruction and work experience, although that is pretty limited. So what does this really mean in English? For the most part, we are talking typically about a college degree and not just any degree. So if you just say, well, this requires a bachelor's degree, that is not specialized knowledge. So we're talking here about you need a degree in accounting, you need a law degree. I'll give you an example. The way that the Department of Labor views, let's take, for example, the financial office, right? If you're a CPA, you're exempt under the professional exemption, if you're a licensed CPA. However, if you're a bookkeeper, they consider that to be non-exempt work because it's not a professional exemption, you don't have enough knowledge required and learning required, and also they don't consider that highly matters of significance and independent judgment enough to be considered under the administrative exemption. They're going to say, well, bookkeeping is mostly just clerical. So I think that's a good distinction to illustrate how they view this. So really we're talking a specialized college degree, a CPA, something that requires a license. So, obviously like teachers, doctors, lawyers, if you have to be licensed by the state, and it's advanced knowledge. So not, if you're an electrician because it's manual work, even though you might need to be licensed, that's not going to get you under the professional exemption.
So the licensed title producer may or may not be under this exemption, or probably is not because there's no college degree per se.
Exactly. Just a license is not enough, but in some areas it's going to help you, but just having a license will not get you this exemption. It really has to be the specialized intellectual instruction. So really we're typically talking about a 4-year college degree required and not just any degree specific to the field.
So Jeremy,
Okay.
put this on all the to-do list. We need a college program that has a title insurance degree in it.
Yeah, that would help.
We'll work on
right,
that. I think, doesn't David Townsend teach a class at Missouri?
We do, yeah, and we've got faculty now, so we can do that, right?
All right, let's move on to talk about the computer professional. This is another one that is near and dear to people's hearts because none of us can work without our computers these days. And so we need our computers 24/7, some of us, and when it's not working, I want to be able to call my tech support people in the middle of the night. I've talked to them in the middle of the night more times than I would like to remember. And so we all want our computer people to be exempt. The problem is that what the Department of Labor in the regulations considers to be exempt is for the most part not the computer people that we really want to be exempt. So here on the salary basis, it's $9.13 a week, or there's this hourly rate. There's a long story behind this why. If anyone's curious, email me and I can tell it to you, but it has to do with Congress when they put that rule into effect. And then you can see, here's the actual language of what you have to do. I'm going to skip ahead and translate this into what I consider to be the English version on the next slide, which is what they're really talking about is computer systems analysts, people who are, writing code and programs, and software engineers. It is not anybody who's basically applying computer software programs and not your desktop help desk. I mean, the Department of Labor sort of unofficially has a rule that says if this is dealing with desktop issues, this is not exempt work. They really want the behind the scenes, creating the systems, writing the code, not making my computer work when I, need it to work in the middle of the night. So this is really a challenge because these are often people who work long hours because you need them available when you need them. But this is an area where the Department of Labor has been very firm on limiting its exemption. Okay, so we're going to talk about one additional exemption in terms of duties and then a quirk. So outside sales. Okay, so primary duty, making sales or obtaining orders or contracts. You notice there's no salary basis, and the important part here to be outside sales is that you have to customarily and regularly be engaged away from the employer's pace of business, and if you are working out of your home is the employer's place of business for this in making sales or obtaining orders or contracts. Phone and internet sales do not count as being engaged away from. So people who are doing phone sales, internet sales, do not fall under this exemption. This is actually pounding the pavement. And there is no salary requirement. If people are really out there pounding the pavement, how you pay them does not impact the exemption. Okay, so the final thing that we're going to talk about is in 2004, the Department of Labor put in place for the first time this it's almost like a hybrid exemption. It's called the Highly Compensated Employee Exemption. And the idea of this is, if people are making enough money and they're doing non-manual work, we probably really don't need to worry about them. So that salary threshold is going to go up to, it's currently $100,000 a year. It goes up to $134,004 with at least $913 paid weekly. So you're going to pay that $47,000 basically a year on the base salary, and then you can do the rest of this by any combination you want of incentive pay, overtime, bonuses, any of those things. And they have to do at least one of those duties we showed before. So you can't have somebody who's, an electrician who's making $134 be exempt. They still have to be meeting one of the duties. And basically what you have with this exemption is the ability to look back at the end of the year and say, did they hit the threshold? And if not, there's a window where you can do a make-up payment. So where people are using this the most is for inside salespeople. where, you know, they basically, you do that base salary, let them be on a commission basis, give them still the incentive to work a lot, and then you can do the makeup at the end of the year. One thing to keep in mind, particularly with this one, is that there's a number of states that have not adopted it. Okay, so now that we've gone through the exemptions, you're like, we've got problems, so what are we going to do getting ready for December 1st? All right, so first thing that you want to look at is if you believe that you have employees who are exempt after going through those tests, but they're not going to be at that $47,000. I mean, that's the first thing absolutely I would do is say, okay, who employees who make less than $47,000 a year who are not paying overtime, right? And then you're going to look at them and say, okay, do we think that they actually meet those exemption, and also what are we going to do about them? So here are the things that you can do. If you really believe that they're exempt and they don't meet the salary requirement, you can make them non-exempt, and then you're going to pay them overtime for all hours they work after you do that, over 40 in a work week. And remember, I said work week, not pay period. It's not 80 in a pay period. Work week is what matters here. Another option, good.
I was going to say that state basis, be careful of that. I think, what is it, California that has defined by day, 8-hour day?
There are some states where you may have to pay daily overtime. You're correct. California would be one of the few. Yep.
Yep.
And there's some other states at above 8 hours where you might, if you've had more than 12-hour days or things like that, there may be premiums, absolutely. Right. Yeah, you always want to know your state law. So that's one option, is pay them, is make them non-exempt and pay them. A second is raise their salaries to the threshold. Pay them the $47,000, the $913 a week, and then keep them exempt. The other option that you have is when they put this new rule into place for the December 1, they basically said, all right, we will let you do up to 10% of that salary threshold, that $47,000 number, through bonuses, non-discretionary bonuses, meaning you have some sort of an announced defined incentive program. So this will work well if you've got, this works well if you've got some sort of an incentive program in place. You're still going to have to pay on a salary basis. You're still going to have to pay, and it's only going to be that 10%. So, that works well if you've got employees who are maybe a few $1,000s short, and so, okay, we'll put a bonus program in place. You have to pay that bonus at least quarterly, and there is that look back similar to that highly compensated employee where, like, they don't hit the bonus you thought they were going to. Can we make it up so we don't have to go back and pay them overtime? So that works well if you've already got bonuses or incentive compensation in place. I think where if you don't have bonuses or incentive compensation in place, I actually had this conversation with a client this morning about whether they're going to do this for some of their people. It's a lot to try and roll out and figure out between now and December 1st. So one of the things that you could do is say, look, we can't afford to raise this person to $47,000 just on December 1st. We're going to go ahead and pay them overtime and, see how that goes for the first year. And then maybe, a year out, or maybe that's even just 6 months out, you're going to say, hey, we want to try and move to some incentive-based compensation and try and not just do the $47,000. In most places, you're going to be fine doing that and changing their salary if you don't have an employment contract, as long as you're doing it going forward, because the employee can always say, no, I'm not willing to accept that, and they can look for another job if they don't want the terms. So you can do that. I mean, these are not choices that are, once you make the choice, you're stuck with it forever. It's just that every time that you make that change, you're going to get questions from employees like, why are you making this change? And once people have been getting overtime, they may like getting overtime, and, it may be hard to change back. But even if you say on December 1st, we're not raising you to 47, and then you start seeing that you can't control the overtime, you would have the opportunity to then say, wait a second, we're going to raise your salary, assuming that they meet the duties test, and you know what, we're just going to make you exempt again because you realize you're paying them far more than 47 in overtime.
Hey, Shannon.
Okay. Yep.
Real quick, if you could define non-discretionary bonuses.
So a non-discretionary bonus just means that it is announced in advance. Like there is a set program where you say, here's the timing, here's what you're going to get. As a discretionary bonus is, you did a great job, I'm just going to give you something that I haven't told you about in advance. And the idea of a non-discretionary bonus is it's an incentive for people to work smarter, work harder, to earn that bonus because they know what they have to do to earn it. So that's a non-discretionary bonus.
All right, thank you.
Sure. Okay, let's then talk about what happens is, okay, we're going to move people to non-exempt, we're going to owe them overtime. How do we figure out what that's going to cost us? How do we decide on the previous slide between options 1 and 2? Do we pay them overtime or do we move their salary? One of the things that I'm suggesting that you do now, we still have a couple of months, but you have to start doing this soon or you're going to run out of time, is ask, basically get people to track their time. These people who, you're treating as exempt right now, maybe you're thinking you're going to move them starting December 1, you don't know how to get a handle on how much time they're working to even try to budget for overtime. One of the things you can do is start saying to them, if they don't already, hey, keep track of your time. And therefore you can get a sense of how much they typically work. If you're picking a very short period of time, like a week, don't pick it, like let's say Labor Day week or a really heavy vacation time. You want something that's a typical week. Even better if you can get a slightly longer period of time to try and get a sense of just the typical hours of the flow. And, you have a couple of months now to do that. That's something that can come in very handy just for planning purposes in terms of you're assessing what you're going to do. And then the next step in this process is, okay, if we're going to remove people to non-exempt, we're going to owe them overtime. How do we limit this overtime? Well, consider policies that require employees to get approval for overtime in advance and enforce those policies. Just having policies doesn't do any good if you don't enforce them. So one of the things that you need to understand is you as an employer have to pay employees for all hours that they work that you know about or that you should have known about. Even if you have a policy that says, you have to get overtime approval for working overtime. Even if you have that policy and they don't get approval, if you know about it or should have known about it because, for example, you walk past your secretary's desk and you see her working while she's eating lunch, you know that she's working through lunch. You can't just look away and be like, I'm going to pretend I didn't know that because you didn't ask me if you could work overtime. You have to pay for that. So you have to enforce these policies by saying, go home. Don't work through lunch. If they're after hours, you're not allowed to do this. Don't let people do the work. You can also discipline employees for the unauthorized overtime if they violate the policy, just like any other policy violation. But if you know about it or should have known about it, you have to pay them even if you discipline them for it. And that's really important because employers sometimes want to say, and sometimes I've seen policies that say, we don't pay for unauthorized overtime. And then like big red pens like, no, we're not going to say that. Because you can't do that. You got the benefit of the work. You can't not pay for it. Okay, so you may be sitting here and saying, okay, it's July 13th. I heard all of this about the, the misclassification. I looked at those duties tests, and I think we're in a world of trouble. What do we do? So my suggestion is this is the time to fix it. If you know you're looking at this and you're saying, we have people who we've been misclassifying. We need to, what are we going to do about this? The reason I say that this is the time to fix it is that with all of the changes that are taking place, there is a whole group of plaintiffs' attorneys out there who do nothing but wage and hour work, who are rubbing their hands together going, we are going to have a feeding frenzy. I spoke on a panel with a plaintiff's attorney and is like, oh yeah, people are really excited about this. Who are going to be out there just looking for any idea. And one of the things that this plaintiff's attorney said to this panel that I was doing was really interesting. He said, so many of the people that we get as plaintiffs in these wage and hour cases, that's not what they called us about. They called us about something else. They called us about a workers' comp claim. They called us about a discrimination claim. They called us about some other thing, and we may think they don't have a good case there, especially on the discrimination, but we now start asking them questions to get at whether they've been mispaid, you know, to create a wage and hour claim. And that's what these plaintiffs' attorneys are doing now. The people don't even go in thinking they've been paid unfairly, but they talk to an attorney about something unrelated, and then they're going to get told that they are, and then they're going to sue. So, and the Department of Labor as well is going to be all over trying to enforce this. And the Department of Labor likes to pick industries where they think that there is widespread misclassification, and then they do industry audits. So it's not that always that there's going to be a complaint by one of our employees. They can just pick an industry and do a or not so random audit. So once you figure this out and you're thinking there and saying, like, okay, we've been misclassifying these people, actually go back a slide for a minute. What are we going to do about it? And so one of the things that you have to do is decide, are you going to pay people back pay? You know, you realize that you've been misclassifying somebody. You have to ask yourself, are you going to pay back pay? Typically, you're talking 2 years. You have to figure out how you're going to calculate it. And if you do, consider that you can't get a release because I said they're non-waivable, but you can get somebody to say, hey, this is accurate, and I agree that I've been paid all the money that I'm owed. The problem is if you don't do that, then and you get sued and you knew about it, what they're going to say is, well, you know what, this was a willful violation, so you're going to have to pay double damages because you don't have what's called a good faith defense. Liquidated damages are 100% of the back pay on top of the back pay, and they're going to say instead of you owing 2 years back, you owe 3. So that's the risk. So it can be very expensive, especially when you're talking about multiple people. And Brent, you had a question, right?
Yeah, I did. I actually had a couple, maybe a question or comment, and then this is kind of out of left field from this, but I was just looking up EPL coverage. This is something for business owners, employers to look at as a possible way to help mitigate maybe fines and penalties. Now, it's very restrictive usually in terms of what limits are out there or what coverage is out there, but EPL is an insurance coverage you want to check out. And
one thing to keep in mind, Brent, on that is that most EPL coverage will exclude the back pay, will exclude the wage and hour claims, so you want to look very carefully. And yes, some of them will consider liquidated damages to be part of that back pay, so they will not pay any of this liability. And sometimes people think it's going to be covered and then it's not, which is a very unpleasant surprise.
Yes, so I think that the key for us, like we have it, but we need to revisit those coverages because the other thing is probably the price that's going to go skyrocket up. But I think from a question standpoint, or maybe an observation, is laptops and cell phones, you know, should have known that burden. So if someone's answering emails on their phone at 9 o'clock at night trying to be, you know, do their job and give great customer service, that's time.
Absolutely.
You almost have to have a policy on that, and I know that's huge. That's the first thing that I heard and almost fell out of my chair on because we all do that. So you have to have a good policy on the time and how you measure that, and then also a policy on when it's appropriate to use your cell phone because that could trigger overtime. So
absolutely.
And then the lunch break. I mean, that's huge. And then laptops. You take laptops home. You know, how are you dealing with that? The other thing I was going to say, and it's probably just it's obvious, but you know, instead of the time and a half, can you work out something with comp time or more vacation time? Is that something that's allowable, Shannon?
Nope. No, unfortunately, again, that goes back to those non-waivable rights. If employees are entitled by law to the overtime at time and a half, they can't waive it. You can't work something else out with them. The one thing that you can do, it's not really comp time, but let's say that somebody works late on a Monday night, and then within the same work week, you could say to that person, you know, you should come in late on Wednesday so that your hours, so we don't have to owe overtime. So some people call it flex time or things like that, but it can only be within the same work week. If you just, so that if there are more than 40 hours worked in that work week and they're entitled to overtime, you have to pay them the overtime.
Okay, excellent. So it's got to be cash money in terms
Correct.
of
cash money at time and a half.
And,
Yep.
and then that's neat to know the flex time in terms of within the work week, and probably, of course, within state regulations too. Yeah, that's the other thing I was going to bring up was going back, and you don't have to go back, Jeremy. The deduction. So let's say you got a salary person, they're making $50,000, and let's say there's a disciplinary thing, there's suspension, or they run out of their paid leave, and you deduct them, $4,000 in that year's time or whatever it is. So now they go below 47. What does that look like?
If they were deductions that were permitted at the time that they were made, that wouldn't be a problem. If they were lawful deductions. So if the person took like an unpaid leave of absence, because they went out on maternity leave or something like that, that's not a problem. If they were deductions that you were allowed to make, because really the threshold is on a weekly basis. It's the $913 a week. So the total annual compensation is good to know for planning, but that's not an issue if the deductions were proper when they were made. You don't have to go back and worry about that unless you're talking about something like the highly compensated employee exemption. But on one of the other ones where it's really just a salary basis, that's fine. Okay, so let's move on. Good.
Travel time. So you got to travel time too, correct?
Yeah, so for non-exempt employees, you may have to pay for their travel time. The rules on that are actually very complicated because it depends on when they're traveling and where, whether it's, overnight travel or if it's just, commuting to and from work, if it's travel during the day. But you may have to pay for their travel time too. And there's just different rules based on different kinds of travel.
As if the rest of this is not complicated.
Exactly. Yes. This is not simple stuff. We could do hours on just the rules for counting time, and what you have to count and not count, and meetings and training, and there's a lot of rules on all of those things as well for non-exempt employees. So one of the things that I wanted to make sure that we talked about is that if you are going to be moving employees from exempt to non-exempt, you really want to have a communication plan, both for morale issues and also to try and minimize people feeling like they now have a claim that they should be making. So you're going to have employees who you are going to be offended. They're going to say, I feel like I'm not a professional anymore when you convert them to an hourly employee, and you're going to have to deal with those feelings and have talking points around that. Also, you don't want to give the impression that, this is an admission that you've been doing something wrong. So you really want to think about that before December 1st, how you're going to message it, how you're going to communicate it, how you can support employees and stress their importance to the company, that this is not a reflection of their value, that this is just compliance with the law. Okay. On to, this touches on what Brent was talking about. You need a plan and policies in place to make sure that all that time worked by non-exempt employees is being captured. That means you need to just have some method to track their time accurately. You need to educate those employees who are not used to having to keep track of their time about the fact that they need to report all that time. Think about if you want to limit access by non-exempt employees to work tools after hours. Like, are you giving people 24-hour access to their, to their computer systems? Why are you doing that if you don't want them working? Or have a system in place to track and pay for that time. Educate supervisors about limiting contact with non-exempt employees after hours. This is when we hear all the time, supervisors send somebody an email at 11 o'clock at night. Why are you emailing them if you don't expect a response after hours? One of the easy things to do is on Outlook and other email programs, you can set a delay time on the message. So the supervisor may be doing it because they're thinking, wow, I need to, do this while it's on my mind, but set it so that it ends at 8 a.m., not at 8 p.m. And then make sure that you are properly compensating for meal breaks. That's another issue that you need to be aware of. The final thing, because I know that we are running out of time, is on the last slide. What we just have for you is just some resources. You've got the DOL.gov website, has some good fact sheets and compliance assistance materials. As we've talked about, Brent has mentioned, there's consulting firms and accountants who may offer audit services. Just keep in mind the attorney-client privilege issues, so that if there are problems, you want to try and involve counsel early on, not only because, hopefully you're going to get a lawyer who's going to give you good advice, and you want somebody who really does this stuff. You don't want a general practitioner who may never deal with wage and hour issues. These are complicated, but you also want that privilege in place if there are problems. And you have our contact information. If you have questions for me, you know where to find me.
All right. Thanks, Shannon and Brent. Yeah, we are at the top of the hour. We have touched on a good majority of the questions. We've received a large volume. It's almost like we have a webinar on the TILA RESPA integrated disclosure rule and how to comply with that. I think that we have a lot of questions specifically about, whether this type of job applies or not. Again, their contact information is there on the slide. We don't have time to address every single job role. Shannon, one point you could maybe cover on the effective date. So if an employee is misclassified before December 1st, is that okay? They can get that corrected, and then it's not retroactive, is it, or is it?
Well, so that's the question is, if they are currently being classified properly, but because they meet the duties test and they meet the current salary threshold, but they're not going to make $47,000 on December 1st, there's no retroactive liability because you don't have to meet that new 913 test until December 1st. If they're currently being misclassified because they don't meet the duties test that were on that slide, you have liability every day that you don't fix it because those rules have not changed. So the bases of the test, all of those duties issues, the administrative exemption, all those issues, they're not changing. So you have liability every day that they're misclassified, that they're working overtime you're not paying for.
Okay.
So it just depends which way what the misclassification is. Is it that they're not going to make the salary basis on December 1st, but they really are exempt by duties, or are they not exempt by duties? If they're not exempt by duties, every day that goes by that you don't fix it is a day you're potentially being sued for it.
Okay, and maybe just a little advice for people on the call. What kind of documentation do you need? You touched on it, but is there any more color you could provide on employee documentation that's needed?
Absolutely. So you want, certainly job descriptions can help you. Job descriptions can also hurt you. If there are policies that are in place that talk about, what kind of authority people have, if you have emails, if you have, employee evaluations that talk about what their responsibilities are. The more that you can show the independent judgment that employees have, particularly under that administrative exemption, or the authority that they have under the executive exemption, if they're signing off on terminations or disciplines or hiring, saving that trail of, having that available to say, no, this person has the authority to hire. Look, here's the emails they sent approving these hires or, doing these hires, all of those things.
Okay, and then maybe just one more. I think it's kind of a broad question. We'll address several who have asked about how to determine if an employee is exempt or not. Do they have to meet all of the bullet points? Okay, first they have the new salary threshold. Do they have to meet the salary threshold and all the bullet points?
Under any of those, if you're under one exemption, yes. So if you're going to say that they're an executive exemption, they've got to meet all the points on that slide. If it's the administrative, it's all the parts of the test for that. There's no ors, it's all ands.
Very good.
So it's the ors, like you don't have to be both a professional and administrative, but if you're going to say it's administrative, you got to meet all of those things.
Okay.
DOL.gov has some resources to check out too in terms of testing and how to evaluate that. Okay,
and then we've just one more, just kind of follow up on that one. Then it seems like there's a little bit of confusion. So this question is: employees who make less than $47,000 must be converted to hourly employees?
With very limited exceptions, that's right. They're going to have to be non-exempt and paid overtime if they're making less than $47,000 as of December 1st. That's right.
Okay. All right. I think we're already 5 minutes after the hour, so we're going to go ahead and conclude today's presentation. Again, the contact information is on the first slide. So Shannon has agreed to answer your questions. Brent's out there as well. Hopefully he is not wearing his pajamas.
Right.
As a reminder, today's webinar was recorded. After we have it edited and processed, you'll be able to access it on ALTA's website at alta.org/title topics. You also feel free to forward me any questions you have at jyohe@alta.org. Looking ahead, our next Title Topics webinar will be held in September, and we'll turn to sales and marketing and how you can get your entire staff involved in this process. In the meantime, we'll hold the third of our compliance webinars next month as we focus on Section C of RESPA. So keep an eye out for more information on these webinars. And with that, that'll bring us to the conclusion of today's presentation. Shannon and Brent, thanks again for joining us. A lot of interest, high volume of questions. About how many people? We had about 700, 800 on the webinar. So thanks for your time today.
Thank you.
Thank you. Thank you. Great job, Shannon.
All right. We hope.
Thanks, Brent. Great job.
Yep. Thank you. Hope all listeners found the presentation useful. Take care, everyone.